Thank you for being here with us today. Welcome to the Capitol Hill chapter and the Regulatory Transparency Project's Luncheon, Congress and the Future of Agency Authority, a discussion of 3 major administrative law cases and their implications for Congress. First, I would like to thank my friend and colleague Savannah Griesinger and her external relations team, and I would like to thank my RTP team, Kayla Kleist, as well as Marie Blanchard and Sarah, who can't be with us today. We're going to have 45 minutes of discussion followed by a question and answer. The questions should have a question mark at the end of them and not be a Shakespearean soliloquy. That's a lot of smart people in this town, but we'd like to hear what our experts have to say. I'll keep introductions brief just so we can get right to the discussion. First of all, I'd like to introduce our moderator, the Honorable Trevor McFadden. He's a judge appointed to the United States District Court for the District of Columbia in 2017. He received his BA from Wheaton College magna cum laude, and in 2006 he received his JD from the University of Virginia Law School, where he graduated order the coif and was editor of the Virginia Law Review. He has served at DOJ and in private practice at Baker McKenzie. Next, we're pleased to have with us Will Yeatman. Will is a senior legal fellow at the Pacific Legal Foundation's Constitutional Scholarship Team, where he helped to take the fight for individual liberty to the modern-day Leviathan known as the administrative state. He holds a BA in Environmental Sciences from the University of Virginia and an MA in International Studies from Denver University, and has a JD from Georgetown University Law Center. He has also worked at the Competitive Enterprise Institute in Cato, and previously had time in the Peace Corps in Central Asia. We are thrilled to have with us Professor Kimberly Wehle. She's professor of law at the University of Baltimore School of Law, where she teaches and writes in the area of administrative law, federal courts, and civil procedure. Prior to the University of Baltimore, Professor Wehle was an associate professor at the University of Oklahoma College of Law and a visiting professor at George Washington University Law School. Her scholarship addresses an array of U.S. constitutional issues, including the separation of powers, which has appeared in the Notre Dame Law Review, the Indiana Law Journal, and the North Carolina Law Review. Please help welcome our panelists to the stage. Thank you.
Thanks, Steve. It's a real pleasure to be with you all. And as Steve mentioned, I've got a background in the Justice Department. As a prosecutor, we have this phenomenon in law enforcement where when you take out one crime lord or one gang, often you get 2 or 3 others kind of replace them, kind of Hydra-like. And that for some reason that image popped to my mind as I thought about the agencies under the microscope there at the Supreme Court this term. I think what happens afterwards, of course the Supreme Court will speak, but it really is going to be up to many people in this room in the first branch as to what really happens with the long term of these agencies. I'm excited to be here with our panelists today to kind of read some tea leaves and suggest to you all what might be some options for Congress and some potential outcomes there. I was going to just briefly review the 3 main cases that we wanted to talk about and then turn it over to the panelists to talk more about the implications of these cases. The ones we're going to talk about for the most time today, there are actually 2 cases, Relentless and Loper Bright, argued at the same day and really raising the same issue. The petitioners there are asking the Supreme Court to overrule its decision in Chevron versus NRDC, which required courts to defer to agencies' reasonable interpretation of ambiguous statutes. These cases both involve a challenge to regulations promulgated by the National Marine Fisheries Service that requires fishing companies to pay for quote-unquote observers who measure the amount of unintentionally caught fish on commercial vessels. Petitioners, fishing companies, argue that the statute does not permit the fisheries service to require them to pay for these observers. The First Circuit and the D.C. Circuit both found that the statute was ambiguous and therefore deferred to the agency's reasonable interpretations as required under Chevron. Next, we'll be talking about SEC versus Jarkesy. It presents three questions. First, whether firing or removal protections for the SEC's administrative law judges violates Article 2's provision that the president must take care that laws be faithfully executed. Second, whether the SEC's in-house adjudication of civil fraud enforcement violates the Seventh Amendment right to a jury in cases at common law. And third, whether the SEC's discretion to bring enforcement actions in-house before an ALJ or a federal district court violates the non-delegation doctrine. Each of these questions is significant in its own right, but the court, in its oral argument, seemed primarily focused on that Seventh Amendment question, and so that's where we'll be focused today as well. If the court were to agree that the Seventh Amendment applies to certain agency enforcement actions, this could force more agency actions into federal court from the outset, thus curbing the agency's enforcement powers. Finally, a Consumer Finance Protection Bureau versus Commodity Financial Services Association involves a constitutional challenge to the unique funding mechanism of the CFPB. Rather than receiving funds through the annual congressional appropriations, the CFPB draws its funds directly from the Federal Reserve without direct congressional oversight. The Fifth Circuit held that this unique funding structure violates the appropriations clause and flouts the separation of power principles. If the court agrees and finds that this structure is unlawful, agencies like the CFPB would be more accountable to the political process, or as supporters of these funding structures would say, they lose their independence. Taken together, these cases have the potential to significantly reshape the power of federal agencies. Depending on how the court rules, agencies will face greater scrutiny from courts in their interpretation of statutes and greater constraint in their ability to adjudicate violations of regulations. In this panel discussion, we will discuss how these potential developments will affect how Congress drafts legislation and delegates authority to agencies. So maybe we can start with you, Kim, as our resident admin law professor. Could you kind of set the table for us? I mentioned Chevron, maybe talk a little more about Chevron deference and how would it relate to these other administrative law doctrines like the major questions doctrine, non-delegation, major questions doctrine, and non-delegation.
Sure, thank you, Your Honor, and thanks so much, Steve, for inviting me. It's really a pleasure to be here. My understanding is not everyone in the room is a lawyer, so I am going to translate this into common sense language if it's really obvious to people. Take a nap or something, but otherwise that's what we'll do. So as the judge indicated, all three of these cases are really important for purposes of the powers of Congress, because across the board for each of these cases, essentially the question is whether Congress acted within its constitutional limits in creating the agencies and giving them the kinds of powers the agencies have. So if we start with Loper Bright, Congress creates federal agencies. The only federal agency in the Constitution that's mentioned is Treasury. So Congress passes laws and creates these agencies. In the laws, the Congress will have instructions to a particular agency. In this case, the statute, the statute is the Magnuson-Stevens Act. The agency is the National Marine Fisheries Service. And in the statute, it said that the agency may establish a, quote, plan that observers be stationed on fishing vessels and, quote, may establish a system of fees and sanctions. And that translated into when Congress gives agencies the ability to regulate, essentially the agencies fill in the blanks of this ambiguous language. In this case, they filled in the blanks to allow observers, which is also in the statute. The statute requires that the boats carry observers with the goal is to prevent overfishing. And they created essentially a funding mechanism that the payment of these observers fell on the fishermen and not on the government. Now, in April of 2023, the government reimbursed all of the fishermen, and that program has been suspended. But essentially, the question that the court has taken up is, okay, when the agency takes a statute that Congress gives them the authority to implement, and they fill in the blanks of ambiguous language, which is inevitable in a statute for a lot of reasons, and the agency does that, does a court look at what the agency did? In this famous Chevron case, which involved the definition of stationary sources under the Clean Air Act, the court essentially said, well, agencies have substantive expertise that judges don't have. There's a benefit to the regulated community to have a single voice. The agencies speak on something rather than various lower court decisions across the country. Regulated community companies can manage for that. And thirdly, as a matter of the separation of powers, Congress handpicked that agency to do this. If that's the case, so long as the statute could go different ways and the way the agency fills in the blank is reasonable, then we'll defer to the agency rather than substituting our judgment as judges for the agency. The reason, as Judge McFadden mentioned, that this relates to the non-delegation doctrine is that back in the 1930s, after the stock market crash and the Great Depression, lots of agencies were created under FDR, and the court was conservative at that point and started striking down this handoff of legislative power to agencies. That's when FDR threatened to pack the court backed off. So we have this longstanding idea that when Congress does that, it's constitutional, but that could be upended because it really goes hand in hand with this idea. Congress says, we don't have the expertise, it's a political hot potato, we can't get votes to fill in all the blanks, we can't anticipate all these ambiguities, so we'll just let the agency do it. What's at stake in Loper Bright is, okay, when the agency fills in the blank through notice and comment, that's the only place they would get deference is when they go through the whole notice and comment period, not other kinds of rulemaking. Do they get deference, or can a court just step in de novo on its own and say, I disagree with what the agency did? So the argument, and we'll have this conversation, I think the argument is, well, Congress is basically abdicating its legislative authority. And the counter argument is, well, it's better to have agencies with expertise do it than judges, with all due respect, that are jacks of all trades, so to speak. So that's the question. Chevron's been cited something like 18,000 plus times. So one of the big questions is not so much what happens with this case, because the fishermen are okay, but secondly, what happens to all of the cases since I think it was 1994, Chevron came down, in which courts gave agencies Chevron deference. Do all of those regulations now, are they all up for litigation and challenge because they got deference? And if that's the case, there's going to be a lot of work for Congress to go back and amend statutes in places where there was deference, and maybe the Congress will say, well, we like what the agency did, we don't want judges to second guess that, so now we'll have to put it in legislation. So if Congress if Chevron is reversed, which is a possibility, I think the argument or the expectation would be there'd be more pressure on Congress, which could be a good thing or a bad thing, theoretically. The other thing that's happened, the judge mentioned the major questions doctrine. Separately, the court has already started to just, I mean, for years it's not really mentioned Chevron. It's kind of taken Chevron cases and not really talked about Chevron, but it's carved out in a case prominently called West Virginia versus EPA, a new doctrine called the major questions doctrine, where the court has already said if there is a statute passed by Congress that has vast economic or political significance, we're not going to defer unless Congress is really clear on what it wants. It's essentially saying Congress has to do it. We're not going to let agencies do it. My argument, and we'll have this conversation, is that in both instances it gives federal judges a lot of power because vast economic or political significance is not defined in West Virginia versus EPA. And without Chevron deference under Marbury versus Madison, it would be judges that would have the power to say what the law is, or we would just have a lot of spaces potentially in our system of government where things that were once regulated are now no longer regulated because the agency would be subject potentially to a legal challenge for having gotten Chevron deference on something they should not have been entitled to.
Maybe I can bring Will in here. You've been a critic of Chevron. Be interested if you could explain why you think Chevron should be overruled.
Indeed. Thank you, Your Honor. So my prism for Chevron is going to be simpler, I hope, and different than that of the professors. And I'll point straight to the dictionary definition. So I've got two of them that I found in some cursory Google searches. Deference, humble submission and respect.
Federal judges have a hard time with that right there.
It's that black robe.
And the second one, similarly minded, is obsequious respect. Now, the way I see things, and I think this is common knowledge, we all learned this in high school and college. Federalist 51, we've got this constitutional system whereby ambition counteracts ambition. That's the animating principle. Well, these definitions of deference that are indeed what is taking place in practice, judges giving obsequious respect to agency interpretations of their own statutes, the statutes they draw their power from. In effect, it's obsequious respect to agencies' interpretations of their own power, okay? Well, that's antithetical to competition. That's not separated branches of government, co-equal, competing. That's, I would say, that's not in the ambitious mold of Justice John Marshall. So that would be my problem, the fundamental problem I have with through the separation of powers lens. And I think the proof is in the pudding. I don't think it's the sole reason that we have an unhealthy imbalance among the separated powers. I don't think it's the sole reason that the presidency is ascendant, that we live in this time of presidential administration where there's 35 odd rules with the force and effect of law for every statute passed by Congress. I'm taking that from Wayne Cruz's at the Competitive Enterprise Institute where I used to work, his unconstitutionality index. He does that every year. The president's initiative when it comes to domestic policy making, again, is going to be a function of many factors, and I won't bore you with my take on them all here, but one of the factors, one of the important ones, is this Chevron deference. It is a big deal. And I did want to, so those are my criticisms. That's my bird's eye view criticism from a constitutional separation of powers viewpoint. But I did want to address just a couple things, because Professor Whele's arguments echo that brought by the Solicitor General. So this notion that the sky is going to fall if we overturn Chevron, it is indeed the case that thousands of decisions since 1984 have cited the doctrine, have leaned on the doctrine. What wasn't discussed at the Supreme Court during oral arguments, and what I have not seen briefed yet, is mention of the statute of limitations. For the APA, we're talking 6 years. Now, I understand that Corner Post, currently before the court, they might be interpreting that statute of limitations. But my point here is where the rubber meets the road, you're talking about the cases that are potentially disrupted by overturning Chevron. It's cases where a rule has been promulgated within the last 6 years that have been decided on Chevron Step 2 grounds that have not been subsequently flip-flopped from the Trump administration to the Biden administration. On Twitter's, or X, whatever we call it these days, I did the back-of-the-envelope math, giving what we know about judicial review and rates of Chevron use. And it's, my guesstimate, well south of 100 cases. So again, that's not chump change by any stretch of the imagination, but that's also not flood, not this sort of existential threat to judicial administratability that perhaps it's made out to be. And then this notion, finally, this notion that, and this was hammered by the Solicitor General during oral arguments, this notion that it's this dichotomy, that it's binary, that the roles of the two institutions, courts and agencies, are the same when it comes to this interstitial lawmaking, this gap filling. That's just not true, okay? So agencies, pursuant to their enabling acts, they make policy, they make big, major policy, small policy, expensive policy, not expensive policy. They rescind policy. It's a tremendous degree of latitude, you know, to the extent their mind can imagine something that would perhaps be plausible under Chevron Step 2, they go for it. In judicial review, the courts can't do that. In judicial review, the courts can say no. It's a check. And this sort of gets back to my prior point about the separation of powers and the proper role of ambition. So I do dispute this notion that, well, geez, if the judges were the Supreme Court to overturn Chevron, then we're in this pill whereby the judges are all of a sudden making law left and right. But no, that's not the case at all. They say no, period. So that's a lot different than being able to render policy, major policy, if you will. So that was my 2 cents.
Thanks, Will. Kim, I'd love to get your response, and maybe you can also hit on something that I think Justice Kavanaugh brought up several times, which is this point that us judges have to interpret complicated statutes all the time where there isn't an agency involved, and we somehow or another muddle through and come to an answer. So this idea that this is a really unusual situation, and of course you shouldn't trust these dilettantes in black robes. Maybe that's not really taking account of what happens in many other areas.
Sure. So a number of points. Now on that, I think the bigger issue, as was identified, is we need laws. I think most people agree we need laws. Who should do the lawmaking? I don't know that anyone would say Congress should not be the one to do, ideally, the lawmaking. Congress has the legislative power under Article 1. That's what the framers anticipated. But of course, it's a sharing of powers, and there are lots of reasons, you all know better than I do, why Congress can't make laws. Last year was an abysmal year for actually getting substantive laws passed. Then it's, okay, so Congress hands off the legislative baton to agencies. Then the question is, okay, is the argument for letting agencies make substantive law over judges is that agencies are accountable at the ballot box through the president. Now, Justice Kavanaugh and others said, well, there's flip-flopping between every 4 years then, but as I mentioned earlier, Chevron deference only applies to what's called notice and comment rulemaking, which actually takes several years, on average, I think 2.5 years, and then it goes through the president's OPM. It goes through another level of review. So it's not so easy to flip-flop on a regulatory basis. But Congress always, today, has the power to abolish all of these agencies. It has the power to abolish every single regulation that people are unhappy with. So one argument is if you don't like it, go back to Congress and have Congress make the laws, and they're not doing it. Now, Justice Kavanaugh's point, I think, and Will's and Judge McFadden's point as well, when you look at what an agency's done, so you let's take Judge Kagan's hypothetical. So Judge Kagan said, imagine you've got a new health supplement, a vitamin supplement, and the question is whether there's a drug within the statute that gave the FDA the authority to regulate drugs. Who decides if it's a drug or not? If it is a drug, then it would go through the protocols for safety for the public. Very, very stringent protocols. If it's not a drug, it gets on the shelf at CVS. So that threshold decision, she would suggest, is better potentially made by doctors, scientists at FDA that can do that analysis. If a judge says, there are a couple options. It's not a drug, then it goes right on the shelf. Then that would be the question, is that the right body to make that determination? Or a judge, as I think was suggested, could say, we're just not going to let this regulation stand. Which is, in a way, what happened with West Virginia versus EPA, which is a big coal power program under the Biden administration that died anyway. So it wasn't that case that did anything. But then you'd have a moment that says, okay, should judges be just deregulating that way and sending it back to the agency to then act within the same statutory mandate, which is too ambiguous, which then puts it back in Congress? So if it goes back to the agency, my question is, if it's the same handoff by Congress and the judge says, well, what you did was not okay, we're now 2 or 3 years until there's more regulation, and the next time they come up to the court might say, it's still not reasonable, or it's still not within the statutory mandate. And then at the end of the day, I think people don't like regulation. Nobody really likes that. I mean, there's a bureaucrat has a negative connotation until an airplane, a piece of it flies off midair. We read about these things, and then the public goes crazy and says, oh my gosh, where's the government regulating? So there is somewhere a balance where we need to have sufficient regulation, but not over-regulation. And I would say on the the Madison Federalist 51 point, ambition, counteracting ambition, there is judicial review of what agencies do, not just under Chevron, but of course under hard look review. So hard look review is essentially under the Administrative Procedure Act, which is the umbrella statute for judges looking at what agencies do. They look to see if the substance of the rule is arbitrary or capricious, which is essentially you look to see if it makes sense or if it's just really dumb. We call it hard look review. You look at all the facts, you look at all the comments. I have my students, when I teach administrative law, actually file comments. There's something inherently democratic about it, and that regular people can file comments on a proposed regulation, and under hard look review, if it's a really good comment, a judge can say, listen, you ignored something really important, I'm going to send this back for you to reconsider it. Can't do that in Congress. But hard look review does give judicial review. It's not just unlimited power. And Chevron Step 2, there have been law review articles on this, basically is the same, kind of mirrors hard look review. It's almost the same standard. And I would also argue that under Chevron Step 1, courts still have the discretion to say, listen, this is clear, which I think Justice Scalia would say, everything's clear and you should never go to Step 2.
Professor, I want to get on to the next case in a minute, but since we've got a room full of folks from the Congress, totally taking your point that it's difficult for Congress to pass statutes, but if there's kind of a sense, heaven forbid that a bunch of generalists in black robes are making these decisions, we want these agency experts to be making the decisions. To what extent is there scope for Congress to legislate to give deference to agencies to say, the secretary shall make reasonable regulations implementing this statute, or just writing, may, not shall, kind of the type of language that we've understood to exude deference. Does that kind of solve this issue, or no?
Well, that's a great question, in that I wonder, when I teach this, I talk about the handoff of the legislative baton. That is, there is in every statute where you get Chevron deference, a provision that says the agency X shall implement this, meaning shall, pass regulations, enact regulations. So if that agency is Department of Labor, the SEC can't run around and start passing regulations. It's only the Department of Labor. And your question, I think, really gets to non-delegation. That is, I really think if people are unhappy with this process, from a constitutional standpoint, to me, the intellectually honest answer is do not let Congress allow agencies to regulate at all. I think that is a more intellectually honest answer than getting rid of Chevron or major questions, and potentially that would make more work for people in this room, but it would put political pressure on Congress to legislate more, which now, given this bureaucracy that is administrative agencies, it's easier to just say, okay, this is so complicated, it's already an 800-page bill, we are under certain pressure, we've got to get this piece in, that piece in. We know the agency will be able to kind of do the stuff that we don't have time to do. When that's off, I do think, I mean, Will said this is a big deal. If that is off the picture, it will change the face of Washington, and maybe that's a good thing, theoretically, for Congress to be doing more. And of course, Justices Thomas and maybe Alito, maybe Gorsuch I know Justice Thomas believes that handoff of power, that enabling thing, shall or may, is totally unconstitutional. But again, that gets to the non-delegation doctrine, and I know we're going to get to this. That might be creeping up, but I would rather have that debate, right? Should Congress be doing more, and if Congress should be doing more, then have agencies only execute the law and enforce the law. But of course, the reason this sort of blew up the first time was because of the Great Depression and the idea that we need more laws and people are suffering because we need to regulate certain entities that aren't being regulated. And so Congress, worked, the Democratic heavy Congress worked with the FDR to produce all these agencies, and then we had the second wave in the late 60s, early 70s, which produced entitlement programs, environmental laws, all of those. And those tend to be now a lot of the areas where Chevron deference gets, I think, tricky and controversial.
But certainly doctrines like Chevron, have in many ways enabled this transfer of power from the first branch to the agencies.
Yeah, that's a great question. Empirically, I'm not sure, but yes, prior to Chevron, there was what's called Skidmore deference,
Right.
which is basically it's optional. The court could say, listen, you guys are smart, or you all are smart, I'm going to listen to you, but I don't have to listen to you. And of course, famously, Chevron itself was under a Republican president's EPA, and the EPA administrator was Justice Gorsuch's mother, and it was actually a pro-industry rule to say, listen, they don't want to regulate pollution that much. So it's now, I think, shifted where politically it's gotten kind of wound up and a little bit thorny, and of course we've also had a lot more regulation, and the world has gotten more complex. So I don't know the answer to that question, whether going back to there would achieve the kinds of objectives that people want across the board. I don't know.
All right, we've got two more cases to chat about and only a few more minutes before we hear from you all. So I want to turn to Jarkesy. As I said, it raises important questions relating to the scope of agencies' adjudicative power. At oral argument, the justices focused almost exclusively on whether the SEC's adjudication of an enforcement action violated the petitioner's Seventh Amendment right to a jury. Will, can you tee this question up? How did we get here, and why does an SEC enforcement action implicate the Seventh Amendment?
Indeed, I can. Well, I'll tee it up by describing some headlines regarding Jarkesy. I don't know if it's Jarkesy or Jarkesy. I've never known. I pronounced it Lucia for like 2 years before I learned it was Lucia.
It's Gary Manders, not Jerry Manders. It's so confusing.
Evidently. So SEC v. Jarkesy, some headlines. I'm sorry, I lost my train of thought. We've been kidding around. All right, so from The Atlantic by Noah Rosenblum, the case that could destroy the government. From Vox by Ian Millhiser, the case that could blow up the government. So there, that's the general tenor of the online legal set regarding this case. So what actually is at issue? The SEC alleges that Mr. Jarkesy, violated securities laws and regulations, and they sought $300,000 in civil money penalties, $685,000 in restitution, disgorgement. Okay, they sought these in their in-house proceedings for their own ALJ, where the entity that ultimately authorized the investigation, the agency head, also has ultimate appellate power. These are big penalties. for this sort of setting? Well, contrary to these headlines, it's actually recent and rare that these sort of big money financial exactions are being adjudicated at the agencies in their in-house courts. And I just completed a study on this very issue, so I've got the numbers on the tip of my tongue. In 1970, there were 0 express statutory authorizations for agencies to prosecute for civil money penalties or restitution in their in-house courts. Okay, 0. Fast forward to 2022. There were 193, that's 187 express authorizations to seek civil money penalties, and then 6 express authorizations to seek statutory restitution. Exercising these provisions, agencies across 1,308 cases, in-house cases, they exacted more than $10 billion. It was $6.5 billion in civil money penalties and about $3.5 billion in restitution. That is a mighty shift. That is a tremendous shift.
And you're saying those all happened in-house, not in front of a district judge?
Indeed, very much so. So these tremendous penalties. I'll note as an aside, the history of these civil money penalties, it only dates to 1970. The history of the penalties per se tell another story. They started out small, $1,000, $5,000. Now we have 7 agencies that can seek penalties in excess of $1 million in their in-house courts. 4 of those agencies can seek penalties in excess of $2 million in their home courts. That's for each violation. Those are big-time stakes. So my simple point here is that with this part, it's recent. For 80 years, we had administrative state, and we had in-house courts, agency adjudications proceeding apace without these remedies. They only evolved since 1970, and in particular after 1978, 77, Atlas Roofing. I assume you get the reference. So they're recent, and then the other point is they are indeed rare. So 1308 is the number for these in-house proceedings that pertain to monetary exactions. There's about 500,000 total administrative adjudications conducted by administrative law judges pursuant to APA 554, 556, and 557 every year. So this subset of enforcement cases that roughly 1,000 for $10 billion is a teeny tiny little sliver of the administrative state. And indeed,
And you don't see any suggestion that those, like every Social Security adjudication would have to go through an Article III court?
not a snowball's chance. No, there's no monetary exaction. The government denying you a benefit in no way triggers Seventh Amendment protections. We could have an argument whether or not the framers should have thought as much, but it's just not the case that the denial of a benefit is an exaction of the sort.
Let me get the professor in here. Do you agree with that? Are we just talking about this kind of small subset of civil monetary penalties? And if so, what's the problem with bringing it in front of yours truly instead of an ALJ?
Well, the proof is in the pudding or in the details of where we're going with this, right? So just to back up for everyone again, Congress creates agencies. Agencies can not just make rules, but they can adjudicate. There's a whole line of cases on whether it should only be Article III judges to adjudicate at all, right? And the court has said, no, that's okay. And they made a distinction between what they call public rights and private rights. And they said if Congress creates a public right, like a right to Social Security, or in this instance, I think the argument would be the public right is to make sure the securities industry that is created by statute and regulated by statute is safe for consumers. I think that's the argument. If it's a public right that is producing a public good, then you can give agencies the adjudicative authority. So in this instance, up until 1990, for the Securities and Exchange Commission, only federal judges could do it. Congress passed 2 statutes in 1990, and again with Sarbanes-Oxley expanded it in 2010 to say, okay, we're going to allow essentially the SEC to decide, do we go to federal court or do we keep it in-house? And it's that distinction that is being challenged here. So the argument I think that Will is making is that, well, here we're talking about fraud, or fraud is, this, just so people know, the Seventh Amendment is in the Constitution. It preserves, if you had a jury trial right in the Jolly Shires of England, way back when, you get in your time machine, Michael J. Fox, your DeLorean, and you go back to the Jolly Shires of England. If you got a jury trial under a writ, a king's writ, you get one today. But of course, Congress makes all kinds of laws that didn't exist back in common law England. So your job is to try to compare and contrast it. And I think the argument Will is making is fraud is something that goes way back then, but a Social Security benefit is a gift from the government. That doesn't go back to common law England. I mean, I see these arguments. I don't think they're frivolous arguments, but they could lose, right? It's possible that when you start down this road, the public versus private rights distinction gets tweaked in a way that you can find under Grand Financiera, which is the major Seventh Amendment case. Because it's a two-part test, right? It's not just, do you have a common law analog? It's, are you talking about money damages or an injunction? You can play with, and the court has basically said the second part of the test is more important than the first part of the test. So there's an argument, I think, and I don't know that it's right, but there's 1,500 ALJs for Social Security. They do 300,000 cases a year. If this were to come out in a way that then that would look like a Seventh Amendment jury trial, right? Because it involves money, even if it's a gift from the government, then we could see this unraveling of ALJs. There's just no way, I think, in this moment to say, oh no, there's this red line around the whole thing, and there's no way really smart lawyers can find a way to, if Jarkesy does, the court finds a reason to say this is a violation of the Seventh Amendment, that it wouldn't go beyond that. And as you mentioned, there are two other challenges, non-delegation, which I think it'll come up eventually, and I think we should have that debate. But then there's the removal question. Right. That I think does put into flux more ALJ appointments if the court does the removal, which we can talk about. But essentially, that would open up the floodgates. For the fraud, we know at least HHS, the Federal Nuclear Regulatory Commission, Department of Labor. There are other ALJs that engage in fraud, so it would have ripple effects beyond just the SEC.
All right. We've got a few minutes left before we hear from you all. Let's just hit really briefly on the last case, the CFPB case. The Appropriations Clause states that no money shall be drawn from the Treasury, but in consequence of appropriations made by the law. Will, maybe you can explain how the CFPB's funding structure is so unique, and do you believe it violates this Appropriations Clause that I just described?
Indeed, thank you, Your Honor. So unique, yes. And I don't know the exact nuts and bolts of I believe it's a request to the Federal Reserve. It's capped at 12% of what the Federal Reserve of their appropriations. However, it's supplemented by this rollover mechanism. Details aside, the point is the agency effectively has the power of the purse for itself. Not only did Congress authorize the agency to fund itself, but, and I'm quoting here, the statute, the Enabling Act, quote, the CFPB shall not be subject to review by House and Senate appropriators. So they didn't just deny them, they didn't just cut them out of the normal appropriations process. They actually outlawed, and I don't know if that's constitutional, to be perfectly frank with you, they outlawed subsequent Congresses from exercising appropriations oversight. That's outrageous. And frankly, to the extent that there are congressional staffers in this room, why on earth would Congress do that? I'll quote Madison again. Madison Federalist Paper number 48, the legislative department alone has access to the pockets of the people. The power of the purse, that is a tremendous core power for the legislature. Why on earth would they give it away? So that just makes no sense to me from a separation of, it's sort of, in my mind, as silly as this notion of obsequious respect for an agency's interpretation of its own authority. I mean, they both defy constitutional logic. But the nuts and bolts of it, is it unprecedented? There are, I believe, two other agencies, the Office of the Comptroller of the Currency and also the Fed Reserve, that have this sort of self-funding power. I'll note with respect to those guys, they are banking regulators. That means they're known as prudential regulators. They charter banks. They oversee the day-to-day operations of banks in a regulatory relationship that is unlike anything else in domestic regulatory policymaking. So I do think the CFPB, with its, it isn't chartering anyone. It is regulating the public writ large, and its executive powers, in particular its rulemaking powers, and indeed its enforcement powers, just on a different level. So I actually didn't think much of this case until a pre-call with my fellow panelists here, and the moderator, Judge McFadden, mentioned the prospect that perhaps if the Supreme Court upholds this arrangement, why wouldn't Congress dip its toes in this well again? And that, frankly, frightened me. I mean, I'd gone into this before that call thinking perhaps this was the least important of all three cases. They're all three blockbuster cases. But that's pretty darn scary, the notion that the CFPB, which is the most recent regulatory agency created by Congress, a regulatory powerhouse, is that the wave of the future? And if so, that stinks.
Kim, you care to respond?
Yeah, I do think it's a big case, in part because no act of Congress has ever been struck down on an appropriations clause challenge. So this is a big kind of swipe at the power of Congress, and it's not just the Federal Reserve and the Office of Comptroller of the Currency, but it's also the FDIC. Congress oftentimes makes lump sum appropriations to agencies who then decide how to slice and dice that piece of the pie. And in this instance, Congress doesn't do that direct funding, but there is oversight by Congress. The Comptroller General, Congress audits the CFPB. There has to be regular reports made to various congressional committees. So Congress is always poised to come back with legislation saying we don't like what the CFPB is doing, right? So the CFPB is a statute that, as you probably all know, combined a bunch of other powers of various agencies and consolidated in one place to protect consumers. And this question came up with one of our regulation that's known as the payday rule, that essentially if you are a sort of a at-risk lender and you get a loan, there are a couple of components of that, but one of that is basically said the lender cannot continue to withdraw automatically from your account after you've had two withdrawals that that didn't work out for you. So the idea is what Joe Biden calls junk fees, like fees and fees and fees. So anyway, that's the challenge to this particular rule, but it's blown up to, the entire structure of the CFPB is unconstitutional, which I think if they win would strike down the CFPB and would have ripple effects at least at those other three agencies. But also on this idea of appropriations, I again think I personally think there should be a tighter link between appropriations and what agencies do. The argument, however, for not just this structure, but these other three banking structures, and I don't know the fact that it's banking makes any difference in terms of whether it's appropriations or violation or not. It's either Congress has to do it or Congress doesn't need to do it. But the argument is that under the appropriations under Article 1, Section 8 for the military, the framers of the Constitution did cap military appropriations determinations at 2 years. And so the argument is if you read those together, it means the framers of the Constitution anticipated that Congress could decide specificity, duration, and source of appropriations, that is, could leave some of those things up for grabs. The idea that appropriation doesn't mean everything about it. Now, I'm not sort of steeped in, that's not my expertise in the appropriations clause, but I think the argument here is twofold. One is, if you have a problem with the payday rule, challenge the payday rule and tweak the payday rule. What we're seeing on all three of these cases are really aggressive, unprecedented challenges to the power of Congress to do this stuff. So for purposes of people in this room, it really would shift the kind of calculus you'd have to make in drafting a bill, right? Because it's not just cases that have been decided under the prior precedent, it's legislation that's been drafted with that in mind, understanding this is the backdrop of how the courts think about what we do. So we're going to do things knowing that if it goes to court, this part will be safe, this part won't be safe. And when you start sort of torpedoing things that have been safe for a long time, like the idea that no challenge, appropriations clause challenge has ever succeeded, it changes the dynamic, and maybe that's a good thing. I mean, maybe disrupting government is a good thing, and we'll get a better government as a result. But to downplay it, not that that's happening here, but to downplay it, I think, is not doing, I think, the public a service when we're talking about these kinds of things.
All right, while Steve is coming up, Will, maybe you can respond to that last, the point that Professor made that, hey, there has been an appropriation here. It was kind of an ongoing appropriation, as she points out. There are other parts of the Constitution that talk about, every 2 years. It doesn't say that here. So what's the big deal? Why is this not perfectly legal?
Well, perhaps at the end of the day, that particular argument will carry the day, and CFPB's funding arrangement will be upheld. I do think that, and this was well explained by the Fifth Circuit, this is a different beast, this CFPB, and its powers are far different from the powers of the sorts of agencies that have been endowed with this sort of authority in the past. So it is, if this legal minutia carries the day, so be it. But to my eyes, there's just something inherently dangerous when a regulatory agency that can write rules and then adjudicate them in its own in-house courts also is unfettered from the power of the purse.
Well, thank you. This is the opportunity for all of you to ask some questions. We have Anna Luis with a microphone over here, and we have Bobby over here. So if you'd like to ask a question of our discussants, please raise your hand, and they will come in. Thank you.
Hi, thanks. Andrew Block, America First Legal Foundation. Just continuing up on the CFPB case, do you think that the rationale would apply to agencies that collect fees, right? So there's a number of agencies like USCIS, FHA, kind of just even getting outside of the banking context. Or is it the rationale kind of fail if you go to fee collection versus this kind of ongoing continuation from the Treasury?
Well, I mean, I guess it would depend, as with any legal circumstance or any legal question. To what extent are the fees the basis of the agency's budget? And this is a function of ignorance on my part. I don't know how it works with these agencies.
It's not actually, so CFPB does not get, it does have fees, but those go elsewhere. So my sense, I don't know if you disagree, Professor, but my sense is that most agencies are not self-funding through their own fees. So it's hard for me to imagine how it would be so broad that would hit all of them.
Yeah, I mean, I think from the meta separation of powers standpoint, it's a good point in that if the idea behind the appropriations clause is that's one mechanism by which Congress manages and controls the implementation of its legislation or execution of its legislation through the executive branch, appropriations, the purse strings, that to the extent to which they're funding and it's creating incentives to create funds, sort of partnership with private actors in a way, it's possible that kind of, theoretically, that kind of arrangement would be equally or at least on the same wavelength as problematic. Like, I agree with Will completely in that there's always, and the judge knows this better than anyone in the room, there are always ways of tweaking and making narrow constraints and deciding, well, we're only going to keep this in this sandbox. It's not going to go to the other sandbox. But there's also always ways to push it. So it would depend on case number 2. If your case came up on your hypothetical after this case found to strike down the CFPB, I don't know what the issues would be and where the court might find a reason to strike down additional agencies once it starts on this appropriations clause litigation track, which we haven't opened yet until this case.
I think we had another question over here.
Thank you. Christina Moore, former congressional staffer, current partner at a law firm, practices in congressional investigations. As I was listening to this conversation, I was reminded of legislation that I worked on a long time ago. We'll just leave it at that. But it would have worked with the Congressional Review Act to kind of enhance Congress's powers to conduct oversight and engage with agencies. And as I was listening to the conversation and the concern with empowering a judge with the ability to look at what an agency has done and judge is that appropriate or not, the question arose to me. I asked my friend here, who knows something about the subject, shouldn't we be looking at CHATA?
Can you say that last?
Shouldn't we be looking at CHATA
You're
and
saying that-
reunite Congress with a legislative veto so that they can conduct the oversight they're intended to?
I mean, I think the court's already held that's unconstitutional because it doesn't go through bicameralism
Right.
and presentment. So you'd have to ask the court to,
That's my point. I mean, we're
Yeah.
asking the court to revisit
Oh,
Chevron.
so we're asking the court to, as
Yeah.
a way of addressing this. Yeah, I mean, like, it's like a hydraulic, right? That's the separation of powers. You take power here, it opens a gap. The whole thing is this hydraulic system, and that might be something down the road if this goes in that direction, as the plaintiffs want, that the court might have to revisit. But that's a tough thing to get the court, even this court, to reverse itself under constitutional doctrine.
Yeah, I echo what the professor said, and I also echo wholeheartedly your thoughts. I lay at the feet of CHATA all sorts of blame for our current predicament, and I'll say this as sort of a Alanis Morissettian irony of CHATA. The evolution, the history of the administrative state is one accommodation after another to the separation of powers. And it is, for example, the existence of a prosecuting and judging entity under the same roof. It just blows my mind that in INS v. CHATA, flexibility goes out the window 100%, and I think we're now sowing what was then reaped.
Well, and the other point is, of course, the filibuster, right? That might be another thing. Filibuster for primary legislation, rather than doing a lot through appropriations, et cetera, might also need to be revisited. And of course, that's an internal Senate rule, not something that comes from the Constitution or a statute anyway.
I'm hiding behind the podium over here. So I would say that most industries that are worried about Chevron are not worried about whether or not an agency has the authority to implement the law through regulation, but whether or not they're making new policy, ostensibly through that process. And so that's the issue. The CRA has proven to be, for the most part, a partisan tool, right? You have to have unified government in order to roll it back. So the lack of the ability of Congress to pass legislation, the resulting sort of done by the pen, undone by the pen sort of whipsaw that industry's involved in kind of brings us to this point. Another alternative that's been discussed is the REINS Act, which would require some affirmative approval by Congress for new rules and regulations that cross a certain economic impact threshold. I wonder what your thoughts are on that as a way forward.
I haven't
Beyond
thought
the
about
ability
it,
to
but isn't that
pass
how the federal rules of civil procedure are done, right? Also, there are other places where Congress kind of just does an oversight look, but and obviously open it to other panelists as well. But that kind of creativity, the suggestion more of a congressional imprimatur without the expectation that we'll just have deregulation in the worst case scenario and expect Congress to step in. That's certainly an interesting thought.
A long, ardent proponent of the REINS Act and what it would do. I mean, sometimes I guess you've got to drag the horse to water, and I think that's effectively what's going on vis-a-vis Congress and the REINS Act. I will note one thing. I do take not issue at all. Respectfully, I do disagree with the tone of the beginning of your question. This notion that there's not enough lawmaking, that Congress is broke down. Lawmaking is supposed to be hard. I mean, it's a big deal. The government is sometimes taking people's property, is restricting their freedom. Like, these are not small matters, and they should not be simple. They should not be easy. They were not designed to be simple and easy. So, it is when we bemoan, I guess, the state of our broken Congress, perhaps that's the system working a little bit.
Well, thank you. Please help me thank our panelists. And I want to thank all of you for attending this first in a series that addresses issues involving the administrative state in Congress. If you want to find out more information like this, you can check out regproject.org. That's regproject.org. And if you are a member of the Capitol Hill chapter, which is a separate part of Federal Society, you can scan this QR code. So thank you very much, and we look forward to seeing you down the line.